Good afternoon. Shall we continue?
I think we're just waiting for one of our panelists. To have a brief introduction of both of our panelists. This is module 5 to all of you. This is nuclear non-proliferation and disarmament and international law. So we will start this time with Mrs. Kathleen Lawand. So for you to know, she's the head of the arms unit in the legal division of the International Committee of the Red Cross. Since joining the ICRC in January 2000, she was posted to India, West Africa, Iraq support, and Afghanistan. And she was also head of the legal advisors to the ICRC operation. You can see her full CV in the platform. So I will give you the floor, Kathleen. Thank you.
Thank you very much. Thank you. Can you hear me?
Yes, we do.
Okay. I had a short PowerPoint, but I'm not quite sure how I would share it, but let me see if I can. That might be a little bit difficult. Why don't I just go ahead? I think, you know, I think people.
Share screen.
Oh, it's share screen, is it? Eh?
And then you'll see a number of.
Yes, of course. I see that there. That's excellent. Thank you. I'm sorry, I'm not used to Zoom.
There you go.
Okay.
You got it?
Can you see it there?
Yes.
Okay. Very good. Wonderful. Okay, well, first of all, thank you so much, Paola, and thank you, Jean, for your kind introduction. Thank you, both of you, for having me on behalf of the International Committee of the Red Cross, live from Geneva, and I'm delighted to participate in this course. By way of introduction, let me begin by saying that the ICRC first called for nuclear weapons to be prohibited already in 1945. So already in 1945, we called for the elimination of nuclear weapons. And this is because we had just witnessed firsthand the horrific impacts and humanitarian consequences of the atomic bombings of Hiroshima and Nagasaki. We were present ourselves, so we went to Hiroshima. Our doctors went to Hiroshima just 2 weeks after the atomic bombing, and we worked alongside the Japanese Red Cross Society and attempted, against all odds, to assist the tens of thousands of people who were laid dying and injured. And this left a very profound mark on us, on the ICRC, and on the broader international Red Cross and Red Crescent movement. And so since 1945, we've been calling for the elimination of these weapons, and we've been repeating that call ever since. And then again in 2011, the entire International Red Cross and Red Crescent movement, of which the ICRC is a part, made a special appeal to states to urgently take measures to prevent the use of nuclear weapons and to negotiate a legally binding international agreement to prohibit and eliminate them. And this in accordance with existing commitments and international obligations. So this was a historic call of our movement. It was much more specific than what we had been saying until then. It was specifically calling for a legally binding international agreement to prohibit and eliminate nuclear weapons. And what did we base this call on? Well, our appeal was based on 3 fundamental observations of the ICRC. The first is based on the evidence of the catastrophic humanitarian consequences of any use of nuclear weapons. And we'd been documenting this. We documented this back in 1945 when we were present, but we had, with the Japanese Red Cross, also been documenting the long-term impacts of radiation exposure. So persons who survived the atomic bombings, but then had been exposed to ionizing radiation emitted by the nuclear bombs. And these persons, many of them died over the following years and decades from radiation sickness and from cancers and other illnesses due to this exposure. So the short and long-term humanitarian consequences were a key factor to our appeal to abolish nuclear weapons. A second important factor is the lack of any adequate humanitarian response capacity to assist the victims of nuclear weapons. And this is based on our firsthand experience in Hiroshima and Nagasaki in 1945, but also on in-depth study that we carried out in 2009 on whether we would be able to provide adequate and appropriate humanitarian assistance in case of use of nuclear weapons. And we concluded this would not be possible. We, the ICRC and the broader International Red Cross and Red Crescent movement just don't have the means and the capacity to do this. The needs, the humanitarian needs in case of a use of nuclear weapons, and in particular even just a limited nuclear war, the humanitarian needs would be colossal. And we as the largest humanitarian movement in the world, we would be unable to provide an adequate response. And then the third conclusion that led us to call for the ban on nuclear weapons is, for us, it is extremely doubtful to imagine any scenario in which the use of nuclear weapons would be compatible with international humanitarian law. That is the law of armed conflict. And I'm going to focus my presentation in particular on this. But before I do that, let me just very quickly refer to certain developments since 2010. So 2010, when the ICRC called for made a very focused call for new law on nuclear weapons, followed the following year by the broader Red Cross and Red Crescent movement making a similar call. I have to say, the ICRC, we very much welcome the shift that has occurred in multilateral debates and processes on nuclear weapons over the last decade. And we've noticed a shift from narrow security interests and concern to a focus on the evidence of the foreseeable impacts of nuclear weapons in humanitarian terms. That is, their unique destructive power, the scale of human suffering that they would cause, the catastrophic and long-lasting consequences they would have for human health, for people, societies, and the environment, and the threat that they pose to humanity as a whole. And it's this evidence-based approach that is critically important and that has been accounted for the tremendous developments since 2010. And here in particular, I would just note that we very much welcomed that the NPT Review Conference in 2010 recognized the catastrophic humanitarian consequences of any use of nuclear weapons and the need, and reaffirmed the need for all states to comply at all times with international law, including international humanitarian law. We also, of course, very much welcomed the adoption of the 2017 Treaty on the Prohibition of Nuclear Weapons. This was a tremendous achievement. The ICRC participated in the negotiations of that treaty and has been promoting adherence to the treaty. And that treaty comprehensively bans nuclear weapons, notably on the basis of international humanitarian law. And the preamble of the treaty makes this very clear. It makes clear, in the view of the states that have adopted it, that any use of nuclear weapons would be contrary to IHL, and it explicitly lists the key rules of IHL that are at play when we consider nuclear weapons. So the prohibition of indiscriminate and disproportionate attacks, the prohibition to use weapons of a nature to cause superfluous injury and unnecessary suffering, and the requirement to take measures to protect the natural environment. And these rules, amongst others, are explicitly mentioned in the preamble of the treaty as the basis, as one of the fundamental bedrocks of why nuclear weapons are banned by this treaty. So turning to international humanitarian law and humanitarian law rules of themselves. Now, why is it still relevant today? Because you could say, well, nuclear weapons are governed by the Non-Proliferation Treaty. There's an obligation, in particular in Article 6 of the Non-Proliferation Treaty, to take effective measures towards nuclear disarmament. All states parties, over 190 states party to the NPT, are bound by this obligation. In addition, now we have a strong prohibition in the Nuclear Ban Treaty, the Treaty on the Prohibition of Nuclear Weapons, although the treaty is not yet in force. And so why is it still relevant to consider the rules the general rules in particular of international humanitarian law, those that I mentioned, the prohibition of indiscriminate attacks, of disproportionate attacks, etc. Why is it still relevant today? Well, it's still relevant because although the TPNW is the only treaty the only treaty today at global level to comprehensively ban nuclear weapons, it's not yet in force, first of all, and even when it does enter into force, it will only, as a matter of law, bind those states that have formally adhered to it. So the states that remain outside of that treaty will not be bound by the ban, and so the question of compatibility of nuclear weapons with the general rules of IHL governing the choice of means and methods of warfare will remain particularly relevant for these states, and in particular for nuclear weapons possessors. So the key question of compatibility of nuclear weapons with IHL remains relevant, and for us the starting point to any assessment of the legality of any weapon is what is the evidence of the impacts of these weapons, of the foreseeable humanitarian consequences of these weapons. What are the foreseeable short and long-term effects of the use of nuclear weapons? And it's looking at those effects that then, and taking this evidence-based approach, that then we can assess whether these weapons can be used in accordance with the rules of IHL. Maybe because we don't have too much time, I'll focus on just say a few quick remarks on first the prohibition of indiscriminate attacks. And this raises the question in particular whether nuclear weapons are indiscriminate weapons as such. That is, are they weapons that are by nature indiscriminate because they are incapable of being directed at a specific military objective, or because their effects cannot be limited in space or time as required by IHL? And there we know that a nuclear detonation releases a combination of powerful blast waves, intense heat in the form of thermal radiation, and high amounts of ionized radiation, which in most cases will be dispersed over very wide areas. And the heat generated by the nuclear explosion is likely to trigger intense fires and firestorms whose effects are uncontrollable, especially when it's used in a built-up area, in a populated area, a city. In addition, there are residual radioactive particles, so-called nuclear fallout, created by the nuclear blast, which are likely to be spread far beyond the target area, carried by wind and other weather conditions, and potentially over very great distances and across borders. It seems, therefore, just on the basis of what we know in this respect, the effects, these effects that I've just described of nuclear weapons, that it would be inherently difficult to control or limit the effects of a nuclear weapon in space and time, to really limit it to the target and the target area. And such sort of broad effects in space and time, and lack of control over space and time, would appear to indicate an attack that is of a nature to strike military objectives, which are lawful targets, and civilians and civilian objects without distinction. In this respect, there are therefore, under this rule prohibiting indiscriminate attacks, serious doubts whether nuclear weapons can be used in accordance with this rule, the prohibition of indiscriminate attacks. Now, what about disproportionate attacks? So IHL, international humanitarian law, prohibits attacks that are launched against military objectives, that is, again, a lawful target against a military objective. IHL prohibits such an attack if the expected incidental civilian casualties and damage to civilian objects, what some call collateral damage, so if the expected collateral civilian harm is excessive in relation to the concrete and direct military advantage anticipated. Now, it is clear that any use of nuclear weapons in or near a populated area would have severe and extensive immediate and long-term consequences for civilians, which are today, based on all of the evidence, the very large body of evidence of what we know of the effects of nuclear weapons, this would be entirely foreseeable. So these extensive civilian harm and long-term consequences for civilians. In light of these extremely severe and long-term impacts, it is very difficult to imagine any concrete and direct military advantage that would justify the colossal civilian harm that would result from the use of a nuclear weapon in or near a populated area, even against a lawful target. And therefore, there are serious doubts about the compatibility of nuclear weapons with the rule of proportionality attack. Again, in particular, when used in or near a populated area. And then finally, and very briefly, I should just note that the prohibition of weapons that cause excessive suffering, so superfluous injury and unnecessary suffering, that the use of the impact of nuclear weapons in terms of the short and long-term illnesses, permanent disability and suffering caused in particular by ionizing radiation, so radiation exposure, that this raises serious questions about the compatibility of nuclear weapons with the IHL rule prohibiting unnecessary suffering to combatants. And to conclude on the application of the general rules of IHL to nuclear weapons, I would like to say a word about self-defense, the issue of self-defense. In its advisory opinion delivered in 1996, so this is the International Court of Justice. I think many of you have heard about the International Court of Justice's advisory opinion on the legality of the use or threat of use of nuclear weapons. And in that opinion, the International Court of Justice concluded that any use of nuclear weapons would be, and I quote, generally contrary to the principles and rules of IHL. However, the court added a very unfortunate qualifier to that. It said it could not decide whether the use of nuclear weapons could be lawful or unlawful, and I quote, in an extreme circumstance of self-defense in which the very survival of a state would be at stake. And this seemed to indicate that the state of international law and the facts at its disposal, at the court's disposal at the time, did not allow it to reach a definitive conclusion about the legality or illegality of nuclear weapons under IHL in particular. Now, for the ICRC, and we've made clear and publicly our views on the issue of self-defense, we consider that the exercise of the right to self-defense, even in an extreme situation where the very survival of the state is at stake, can on no account release the state from its obligations under international humanitarian law. That is the very body of law that it aims to protect civilians and humanity from unacceptable consequences of armed conflict. So in light of all of this, all of this, and the analysis we've done under the rules of IHL maintain for us the significant doubts that nuclear weapons could ever be used in accordance with IHL. Now, I would have some other remarks to make just by way of conclusion, just very quickly, regarding the Non-Proliferation Treaty and the Treaty on the Prohibition of Nuclear Weapons. I will be very brief, and then certainly in the Q&A, there may be a chance to come back on this. But for us, we note Article 6, as I mentioned before, of the Non-Proliferation Treaty. The Non-Proliferation Treaty, which remains the cornerstone of global nuclear non-proliferation disarmament efforts, and this is recognized explicitly in the preamble of the Treaty on the Prohibition of Nuclear Weapons. And Article 6 of the NPT represents the nuclear disarmament pillar, as it were. It embodies the obligation of states to pursue and, as interpreted by the ICJ in its advisory opinion, bring to a conclusion negotiations on effective measures relating to nuclear disarmament. However, the treaty is at risk, the credibility of the NPT, as it were, is at risk of being undermined because of the lack of progress on this critical objective, and we would say ultimate objective of the NPT, which is nuclear disarmament. So this is an important point to make. Also, a very strong action plan was adopted by the NPT states parties in 2010, 10 years ago at the review conference, but it's fair to say that there has been little or no progress to implement the 2010 NPT action plan, in particular by nuclear weapon states. And so this again is weakening the norms of the NPT, and in particular the nuclear disarmament requirements there. Linking the NPT to the TPNW, the Treaty on the Prohibition of Nuclear Weapons, which, as I said, was adopted in 2017. It was adopted 3 years ago on the 7th of July. We just celebrated the 3rd anniversary 2 days ago. The TPNW, as I've mentioned, is the first international legally binding instrument prohibiting nuclear weapons. And as such, it is filling a legal gap, because nuclear weapons, until the TPNW adoption, were the only weapon of mass destruction that was not expressly prohibited under international law. So chemical and biological weapons had long been prohibited and comprehensively prohibited, but the elimination of nuclear weapons had not. And now this has happened in 2017, leading to the delegitimization of nuclear weapons, which is a prerequisite in our view to their prohibition and elimination. And I will conclude with this, just linking to the NPT and Article 6 in particular. Article 6 of the NPT, as I said, requires states parties to take steps to and to take effective measures towards nuclear disarmament. And we are of the view that the TPNW, the Nuclear Ban Treaty of 2017, is an effective measure within the meaning of the NPT's Article 6, and as such, it directly implements Article 6. It's a concrete step towards the elimination of nuclear weapons. And it complements the NPT and the NPT's obligations. So this is why we have welcomed this instrument, and we are promoting, actively promoting its adherence to the treaty, and calling on all states to join it as soon as possible. Thank you very much. Thank you.
Thank you very much, Kathleen. Now I'll just present briefly our second speaker, Mr. Alejandro Alday González. He's currently the General Director of Matías Romero Institute and member of the Mexican Foreign Service in 1998. He has served at the Permanent Mission of Mexico to the Organization of American States and at the Mission of Mexico to the UN in New York. From 2015 to 2019, he was the legal advisor of the Ministry of Foreign Affairs. Please, Mr. Alday, you have the floor.
Thank you very much, Paola. And at the outset, I would like to express again my gratitude for this invitation to Jean Dupree from the CNS, Kathleen, and to share with Kathleen Lawand in this panel. I would rather go to the general structure of disarmament norms in international law in order to identify why are different norms and why are organized in the international context in a set of treaties and customary international law. But that is important when we are trying to interpret if a given country is complying with or not one of these norms. From a legal point of view, disarmament is a broad term which encompasses the complete destruction of certain weapons, usually the weapons of mass destruction, but also the non-proliferation, limitation and control of some categories of weapons or specific weaponry. Also, under international law, disarmament norms constitute a legal framework that coexists sometimes in tension and sometimes some others in harmony with the international law of sovereign would entitle the states to protect their national security, even though the use of weapons. As you may know, there are two main sources of international law, the customary law and the treaty law. The first one could be defined as the practice of states that becomes binding through the time because of this generally accepted by states and by the same states. Treaty law means the written norms result from international negotiation. That is very basic understanding of the sources for international law. You are diplomats and you are familiar with it. But considering that the use of weapons is not generally prohibited by international law, and this is important to underscore, most of the rules limiting the development, use, and transfer of some weapons are included in international treaties. From a legal point of view, states negotiate willingly to limit a sovereign right to have access to the means to maintain their own security with the goal of reducing their weapons. Nevertheless, this self-limitation is not exclusively consensual and optional. Most, if not all, international conventions of disarmament are driven by the principle of the law of armed conflict, better known as IHL, as Kathleen has just pointed out, and stating that the choice of weapons of the parties to armed conflict is not unlimited. Then we have this, to be very clear, the weapons are not prohibited at all. Certain weapons are not prohibited at all, but the choice of the parties are limited. The development and use of weapons are limited by treaty law and customary international law, mainly by the rules reconciling the military necessities of the parties to a conflict and the limitation of human suffering. This principle has been included for a number of years in the international law, such as in the Hague Regulations of 1899 and 1907, and more recently by the additional Protocol 1 of the Geneva Conventions of 1977. International law, international conventions on disarmament usually deal with specific weapons, chemical, nuclear, or biological, or with type of weapons, conventional weapons, or weapons of mass destruction. That's a very basic division. These instruments are drafted to deal with specifics of these weapons, and they recognize the threat that their use or development tender for international law and human security. Customary international law also prohibits the use of certain weapons based on their effects, especially in relation with international humanitarian law, international criminal law, and human rights law. Therefore, it is important to have in mind that international legal framework of disarmament is composed by rules of different nature and objectives, but all have in common in the implementation results in the limitation of the use, development, and transfer of certain weapons. We could classify these rules, the international legal framework, as follows. First, the customary norms that would render as illegal the effects of the use of some weapons because they violate a rule of international law, either humanitarian law, criminal law, and the human rights law. Examples of the rules are mentioned in the International Court of Justice advisory opinion on nuclear weapons that I've just mentioned by my colleague Kathleen. The second classification of these rules are the conventional norms of IHL, criminal law, and human rights law that we consider as illegal the use of certain weapons. For example, the Geneva Conventions, the ICCPR, the International Covenant on Civil and Political Rights, and also the Rome Statute of International Criminal Court. Those instruments consider the illegal, the use of certain weapons in certain contexts. That's why we included them as conventional norms. Thirdly, the conventional norms of disarmament, particularly on disarmament, dealing with specific weapons and the type of weapons. Again, the chemical, nuclear, and biological weapons, and as a type of weapons, the conventional or weapons of mass destruction. It is important to underscore that not all of them, not all of the conventions aim for the absolute abolition of specific weapons, but instead there is a broader spectrum of goals and objectives within this collection of instruments. And I propose to include it in 4 types of treaties. The first type are the conventions with the specific goal of the absolute abolition of certain weapons. For example, the Ottawa Convention related to the anti-personnel mines, which is a convention from 1997, is almost universal. And the second is the Chemical Weapons Convention. It's a convention on the prohibition of the development, production, stockpiling, and the use of chemical weapons on their destruction. It's from 1992, and this is a true universal convention with 193 states parties. Another one is the Biological Weapons Convention on the prohibition of the development, production, and stockpiling of bacteriological, biological, and toxic weapons, and on their destruction. It's almost universal as well. This convention is from 1975. And finally, the Treaty of the Prohibition of Nuclear Weapons, which is the most recent of this set of instruments of 2017, with only 38 states party. But it's a great effort. It's the first treaty that establishes the ban for nuclear weapons, and still has a lot of work to do to get into force and to bring all people as a member states of this member states party of this treaty. The second type of conventions is those with the objective of limiting the use of the development of certain weapons based on their effect in relation to international law. And here we have the Convention on Certain Conventional Weapons, the CCW, which is from the 80s, and with 125 states parties. We have the NPT, the Treaty of Non-proliferation of Nuclear Weapons, which is the most clear example of this type of conventions with the objective of limiting the use of development of certain weapons. And the third type of these conventions is those that are aimed to control the international transfer of weapons. For instance, the Arms Trade Treaty, the ATT from 2013, which establishes common standards for the international trade of conventional weapons and seeks to reduce the illicit arms trade. We have also at the inter-American level the CIFTA Convention, but those are clear set of norms established to control the international transfer. They are not dealing with legality or not of the type of arms that are in the trade. And the fourth type of these international treaties are the conventions of criminal law that are aimed to impose criminal responsibility to individuals for the use of certain weapons. And the most clear example of this is the Rome Statute for the International Criminal Court, the ICC, which is a relatively new instrument from 1998 and with 123 states parties. And this treaty considers the use of certain weapons as a war crime. And this is important because the examples for the use of weapons that the Rome Statute considers as a war crime establishes individual responsibility are the poison or poison weapons, asphyxiating or poison gases, and or liquids, bullets which expand or flatten easily in the human body, and methods of warfare which are of a nature to cause superfluous injury or unnecessary suffering. So this is how the international legal framework organizes different rules and the type of conventions related to disarmament. Let me share with you some remarks as a way of conclusions. All the legal arguments are binding, and the violation would generate international responsibility of the state party. Exemption made by the International Criminal Court Treaty that I just mentioned. However, their obligations differ depending on their scope and their objectives. If we think in the convention with the goal of absolute abolition of certain weapons, generally deals with weapons of mass destruction, then the obligations prohibit the use, the stockpiling, the production, and the transfer of these weapons. The example that I would like to share is the Ottawa Convention. Other conventions dealing with the effects of the use of certain weapons may or may not mention specific weapons, but they prohibit or limit the use of possession not because of the weapons themselves, but because of their use in some or in every foreseeable circumstance would violate the norm of international law. And their example, and the most clear example here, is the Non-proliferation Treaty. And finally, the conventions dealing with the arms control that do not aim to prohibit the use or possession of weapons, but they establish a set of restrictions for the transfer based on criteria such as their humanitarian impact and the preventing of the illicit transferring. And again, the ATT is a good example for that. Second final remark, it is important to mention that in relation to the future development of new weapons, from a legal perspective, and I underscore this, there is no need for a new treaty to deal with these weapons to foresee the legality of their use, possession, or transfer. International customary law and the treaties of IHL, human rights, and criminal law are clear regarding the illegal effects of some weapons, either because these are not proportional, they are excessive, or because they are indiscriminate, including here some of the principles of the IHL. Another remark, one specific rule dealing with the future developments is that of Article 36 of the Additional Protocol 1 of the Geneva Conventions of 49. This article states that in the study, development, acquisition, or adoption of a new weapon, means or methods of warfare, the party, the high contracting party, is under an obligation to determine whether its employment would in some or all circumstances be prohibited by this protocol or by any other rule of international law. And this disposition is covering all the existing legal norms of international law. It is important to mention that this rule does not refer exclusively to the potential provision of a new weapon under IHL, but by general international law. And so if you look at this Article 36, it's very interesting when we compare with the sophisticated developments of some other type of weapons, the automatic or the semi-automatic weapons. They are already covered by this disposition in my mind. Let me make reference quickly to the advisory opinion as well of the ICJ. It's impossible to talk about the linkage between disarmament norms and non-proliferation with the international law without making reference to this advisory opinion of the ICJ of 1996 related to the legality of use of nuclear weapons, and Kathleen has just mentioned. The court faced a major challenge here when the submission was made by the General Assembly of the UN. It was also sent some questions by the WHO, but they were dismissed by the court. The major challenge was that the court had to pronounce on the validity of the conduct, which was, and I add, which is the cornerstone of the defense policy of the big powers. Needless to say that the nuclear powers make use of all the possible arguments at hand to demonstrate the lack of any expression of prohibition on the use of nuclear weapons under international law. And even further, Kathleen just mentioned, they defend the right to use them in self-defense, making an interpretation of Article 51 of the UN Charter in a very convenient way, I must say, as a personal note. Third, on the other hand, the arguments of the other group went through all possible scenarios related to unnecessary suffering of civilians by the spread of the radiation, the damages to countries outside the war, the annihilation of relief services, and a big, etc. As was pointed out in the previous model, there are two different communities. One community is the deterrence, and the other is the disarmament. And in this particular submission to the court, they confront arguments, many of them very, very clever, I must say, to make their own points. But the ICJ concluded by 7-7 votes, and this is also it shows how divided is the world about this, and that the threat of use of nuclear weapons violate in principle the law of armed conflicts. But it added, however, that it could not conclude whether such threat or use would be unlawful in circumstances of self-defense or if necessary for the survival of state. And in different discussions later on in the context of the UN or the ICC, when people and countries propose to include the use of nuclear weapons as a crime, for instance, a crime of a war crime, it was an eager and a very in extensive debate from the nuclear powers against the other group, defending this particular opinion of the ICJ in order to not include in the Rome Statute as a war crime the use of nuclear weapons. There are another weapons, but they're not the nuclear weapons because there is no basis, according to them, in international law, to consider that they are prohibited. The court set aside arguments based on the provision on the use of chemical or poison weapons because that treaty was negotiated, in the words of the court, in its own context and for its own reasons, and nuclear weapons never were part of negotiation. This argument was right, actually, but the courts normally have to interpret in general all the arguments that parties provide to them. Secondly, it asserts the court that the 1907 Hague Regulations and in 1925 Geneva Conventions, which bans the use of chemical, bacteriological, and similar weapons, those do not apply to nuclear weapons. Moreover, the court affirmed that the practice of state demonstrates that the terms have been understood in their ordinary sense as covering weapons whose prime or even exclusive effect is to poison or asphyxiate, and not as covering nuclear weapons. That is the extent of the arguments of the International Court of Justice in a matter that it was so delicate for the humankind. The third argument the court was inconsistent with is with its own findings, after correctly noting that the phenomenon of radiation is said to be peculiar to nuclear weapons. Then the court ignored the fact that such radiation, which is specific to nuclear weapons alone, affects only living matter, which actually is the very property that defines chemical weapons. So such argument is equivalent to stating that if only merely adds explosive to a chemical weapon, it is no longer chemical. And finally, I want to share with you one of the arguments of one of the judges in a dissenting opinion, because as you can suspect, there was a lot of criticism around this opinion of the International Court of Justice. And one of the judges, a dissenting opinion, stated that the court reasoning amounted to saying that if an act involves both legal and illegal consequences, the former justify or excuse the latter. So it was very difficult for the court to get the balance that in other cases and requests for opinions, they normally match. In this case was very difficult to follow the court in some rationale related to what is acceptable according to international law. So I will stop here, and again I would like to thank you for the invitation to this panel. Thank you, Paola.
Thank you very much for your presentation. I think it's time now to move to the Q&A session. Sure. So we will first have the question from Gonzalo Vázquez from Guatemala. Thank you, Jan.
Gonzalo, go ahead.
Thank you very much. I have a question for Ms. Lawand. As the use of nuclear weapons are contrary to the principles of military necessity, distinction, and proportionality, how do you believe the international community should react against the use of nuclear weapons, including actions of governments and international organizations? On the other hand, witnessing that some countries seem to be sending signs against the current international order based on rules, how effective do you believe the current legal framework would be to prosecute the individuals that make use of a nuclear weapon, especially if the user is a citizen from a state non-party of the Rome Statute? Thank you.
Thank you very much for that question, Mr. Gonzalo. Can you hear me? Yes, okay, that's great. I think I would begin by saying that in a sense, the international community has now reacted very, very clearly to the conclusion that the use of nuclear weapons would generally be contrary to the principles and rules of international humanitarian law. And that reaction is the adoption of the Treaty on the Prohibition of Nuclear Weapons in 2017 by 122 member states of the UN. So it is really the large majority of states that have adopted this treaty. And so I think that's a very important reaction. And it is indeed, as I mentioned in my presentation, the adoption of that treaty, by adopting that treaty, states explicitly stated in the preamble of the treaty that they were doing so because there was an incompatibility, in their view, of nuclear weapons with international humanitarian law. And they made this very clear in the preamble. So there has been that reaction, but of course the challenge now is, the treaty is not yet in force. There are 39, because Fiji just ratified 2 days ago, so that's very positive. There are now 39 states parties, but the treaty needs to enter into force, and that will create momentum, and hopefully more states will join. And obviously the objective is for the majority of states to join, and eventually all states to join the treaty to really solidify this new norm based on international humanitarian law, comprehensively prohibiting nuclear weapons and outlawing them. And as I mentioned very briefly in my presentation, if you look at the history of international humanitarian law as it applies to weapons, and we've talked about and Mr. González just mentioned this, the Chemical Weapons Convention, the Biological Weapons Convention, and other treaties that prohibit or regulate weapons. All of these treaties, I mean, it's by prohibiting a weapon that you, and delegitimizing it, that you create the basis for the elimination of the weapon. And so it really is a prerequisite to eliminating these unacceptable weapons to delegitimize them. That is to say, under international law, these weapons are unacceptable, they are unlawful. So that is critically important, and this is why you know, that we're calling on all states now to support the nuclear ban treaty and join it and so on, to make it a new law at global level. In terms of prosecution for use of nuclear weapons under international criminal law, of course, any use of nuclear weapons that would violate or constitute war crimes or crimes against humanity under the definitions of the Rome Statute would be covered by the Rome Statute. And I think, again, Mr. González has referred to the Rome Statute there. And that is, I mean, that I think is very clear under the Rome Statute in a sense, so there are the general, you know, war crimes under the Rome Statute, so the, you know, direct attacks against civilians, indiscriminate attacks, etc. And then the violations of these rules would then create a crime under the war statute that could be prosecuted. So the use of any weapon to commit these crimes, be it a nuclear weapon or another one, would be then prosecutable, if you will, under the Rome Statute. I think the other track, and Mr. González mentioned this, under the Rome Statute is weapons, the use of certain weapons which per se would constitute war crimes. So the use of poison weapons, etc. And yes, there have been moves by some states to make it so that the use of a nuclear weapon would constitute a war crime under the Rome Statute. This will need, of course, the majority of member states of the Rome Statute to agree an amendment to the statute of the International Criminal Court to allow that. And even then, that amendment would only bind the states that join the amendment and recognize it. But certainly, it is certainly a legitimate question to ask, well, should the use of nuclear weapons per se be defined as a war crime? And certainly many states believe so and have said so over the years and have made such efforts under the Rome Statute meetings. My sense personally is that really the efforts, I think those are interesting efforts and certainly legitimate. And those efforts will probably be made easier over time if indeed progress is made towards entry into force of the nuclear ban treaty, progress towards universal adherence of states to the nuclear ban treaty, and then critically also in parallel and complementary, all of this is, you know, all of these are complementary pieces, progress towards you know, faithful implementation of the Nuclear Non-Proliferation Treaty, the NPT, and its commitment to nuclear disarmament under Article 6, and the commitments states have made to take steps towards nuclear disarmament in the 2010 Action Plan, in addition to committing the entry into force of the Comprehensive Test Ban Treaty, which is still not entered into force after over 20 years since its adoption, and so on. So all of these you know, legal frameworks fit together and should work together towards the ultimate goal of a world free of nuclear weapons. Thank you.
Our second question from Alina Cañas.
Can I just, sorry to interrupt, if I just ask those who have questions, please don't turn your microphones on until you are called upon to do so. Alina, go ahead.
Thank you very much for your interesting presentations. I was wondering if you could talk about the different options available for non-nuclear weapon states under international law to require nuclear weapons states to comply with your obligations under Article 6 of the NPT. You already spoke a bit about it under international criminal law, but I was wondering if you could speak a bit more. And then related to that, I will be very grateful if you both could express your opinions about the ICJ judgments concerning the Marshall Islands cases, the ones that they filed against the nuclear weapon states in 2014. Well, in the end, the court did have jurisdictions for some cases, and then in others there was no legal dispute according to them. So I was wondering, what do you think about it? Thank you.
Who would like to take it? Alejandro, Kathleen?
Well, I think I can take this, the second part of the questions of Salina. I think the ICJ, like in many cases, always try to get some balance. It's very difficult to find a decision of the ICJ either in the advisory opinion or in the jurisdiction that confronting two or more states that doesn't try to get some balance. I think this is the case in the judgment of 2014, but I don't see as a clear the definition of what the Marshall Island was looking for. But still, there is some step forward for that. Going to well, I think the ITP was for Kathleen, who was elaborating about that.
Thank you. Yeah, it is a difficult question, I find. Because it's at some level, it's also what underlies the question is the weakness of international law. I mean, there's no real enforcement mechanism of international law apart from these voluntary mechanisms like the ICJ. I mean, states can take cases to the ICJ, but normally, you know, the jurisdiction of the ICJ must be recognized. In 1996. States were able to take the case to the ICJ because of a vote in the General Assembly. So that could be a route. I mean, so if we can imagine options for to take your question, Aline, the options for non-nuclear weapon states to require nuclear weapon states to comply with their obligations under the NPT, you could, and we've heard these rumors now going around, you know, in recent years, you know, 30 odd years or more after the ICJ's advisory opinion, that maybe, you know, some states have been saying maybe it's time to bring this back to the ICJ because nothing has happened in the last 30 plus years to really make, you know, make progress towards nuclear disarmament. On this, I should mention what was very interesting in the ICJ, what it found is that there was an obligation of NPT states parties under Article 6 to achieve nuclear disarmament. And it said this is not just an obligation of means, meaning, and because under international law and in domestic law as well, we distinguish between an obligation of means and an obligation of result. An obligation of means is your requirement is to, in good faith, do the best you can to reach a result, but you're not necessarily bound to reach that result. The legal obligation is all the means that you will put to reach the result. An obligation as a result is you have to achieve the actual result. So there's this, you know, the international lawyers distinguish these two types of obligations. Well, what's very interesting is the ICJ said explicitly the Article 6 obligation under the NPT to nuclear disarmament is an obligation of result. States parties have a requirement to achieve nuclear disarmament, and they must do so, you know, forthwith and in good faith. So, you know, the ICJ was quite clear on this. It also went beyond that. It said this is an obligation of customary law. So this is not just something codified in the treaty, but referring to Mr. González's introduction on, the sources of international law, this is also an obligation of customary law. So there's quite a strong basis in international law to say there is a requirement to achieve nuclear disarmament. And one could imagine as a means to, push nuclear weapon states from a legal process perspective to advance on this. One could imagine states maybe going back to the ICJ. Yeah, I think I'll end it there. Yeah. Thank you.
Thank you very much. Our next question is from Andrew Rogers from Jamaica. Andrew?
Good afternoon, colleagues and presenters. Thank you for a very...
I think we cannot hear you correctly. Can you try again, please?
Are you hearing me now?
There's like an echo.
Sorry. Well, I was asking the question about, since states have not detonated a nuclear bomb since 1945, and there is a belief by a sizable amount of states that nuclear weapons are not okay, why is there hesitation then the use of nuclear weapons as law?
Andrew, I think I will try to read your question so that will be easier. So the question is, what is the hesitation of states to characterize the use of nuclear weapons as contrary to customary international law? That's the question. Either Kathleen or Alejandro would like to comment.
Well, because it's on international customary law, you need the same interpretation of a number of countries regarding the same conduct to consider it customary international law. Not is the case with nuclear weapons. Some countries, in particular the big powers, consider that they need the nuclear weapons as a deterrent for their own security and as a deterrent for others developing nuclear weapons. I think that is the main criteria to break the path to a customary international law.
Do you want to add something, Kathleen, or should we? No? Okay.
No, I would just say I completely agree with what Alejandro has just said. And this is the big obstacle, of course. The real obstacle here is definitely opinio juris. And you have, in particular, nuclear weapon states who consistently say that for them nuclear weapons are lawful and could be used lawfully, but the lawfulness is very much tied in to, as I mentioned earlier, this concept of, in an extreme case of self-defense where the survival of the state is at stake, then they would justify the use. And this is what we contest, because it seems to be tied into, it seems to mix what we call the jus ad bellum, so the law relating to regulating the use of force between states under the UN Charter, and the law relating to, in particular, under the UN Charter to self-defense, Article 51. It mixes that with international humanitarian law and the law of armed conflict and the requirements under IHL, which are two completely different things. A use of force could be completely lawful under the UN Charter, okay? It could respect collective use of force under Article 2, Paragraph 4 of the UN Charter with the blessing of the UN Security Council, or it could be a scenario of self-defense under Article 51. It could be perfectly lawful. But if the way the parties are conducting hostilities and conducting warfare violates IHL. This is an IHL violation. This is contrary to IHL. And vice versa. You could have a completely unlawful use of force between states under the UN Charter, but then when they're fighting each other, they're respecting IHL. And these two bodies of law need to be kept separate to respect their integrity. And the problem with this notion of, well, nuclear weapons are generally unlawful under the law of armed conflict, i.e. IHL, except if they're justified under self-defense. And then you're bringing in the notion of self-defense under the Charter. You're mixing these two very different concepts and bodies of law, and this is very dangerous. This is undermining international humanitarian law and the integrity of those rules that are meant to protect, as I said, civilians and humanity.
Very much. We have two more questions. The next one is from Aldo Perfecto Alexandro. Please, Aldo.
Yes. Good afternoon, good morning, good evening, everyone. Can you hear me?
Yep.
Thank you very much. Well, first of all, I just like to thanks for the amazing presentations that we have heard so far. I just was wondering about the moral dimension of all what we have just discussed. And actually, if there is any body of rules, disciplines, and standards that is the closest to the moral dimension and the ethical dimension of international law, is precisely the IHL. Yeah, and it's the closer probably to the very concept of humanity. So actually, I was wondering, coming from a region that is very proud of its legacy regarding the international and the American international law, including the Tlatelolco Agreement and being part of a non-nuclear weapons zone, I was just wondering about the legal and moral arguments that has been posed by the nuclear weapons states. What are there actually, I mean, we have so far heard about the strategic arguments, legal or pseudo-legal arguments justifying the possession, acquisition, or even the use of this kind of weapons. But so far, I don't remember ever having heard about any moral argument behind their possession. So, and I'm not in any way suggesting that from our region, of course, we are very proud of being coming from a region that is coming from a non-nuclear zone, but I'm not suggesting weaponizing moral arguments on our side, but definitely I would like to hear more about what are the moral arguments from the other side, from the nuclear weapons states or others that have been developing this kind of weapons. I mean, I will leave it there. I'm sorry for thinking, I didn't want to read my question, but just to think in my mind. I thank you very much.
Thank you, Aldo. Alejandro, you want to begin? Yes.
Okay. It's very complicated to include the moral part of within the international law. Certainly, the IHL provides a better frame for these linkages between the moral and the law. But we cannot ignore, Aldo, and this is my personal opinion, we cannot ignore the world that it was created after 1945 when the UN was established. There is a clear intention to get the peace around the globe and development and so on and so forth. But at the same time, 5 countries, they reserve for themselves the most important parts of the organization to continue exercising their own power and to auto-control among themselves. So I think the argument of the nuclear weapons has been round and around during the years, saying that they have some duties as big powers for the peace and security globally. And this is very difficult to understand if you think that all countries have the same rights, and but in fact they're not. And that is my opinion. They have reserved some special spot within the organization that they control, and they can put in motion when this is decided. And by doing so, they can cover all arguments of morality, of necessity, of self-defense, and so on and so forth. You can see nowadays a discussion that the UN, for instance, related to Article 51 and self-defense, as Kathleen was mentioned. Some countries are making use of the force, which is in general prohibited by the Charter, arguing that they have to defend themselves from non-state actors, the terrorists, for instance. So this is a big debate in New York because the Charter has not changed. The ICJ opinion for the use of force in self-defense, individual or collective, has not changed. And by the fact, some countries are trying to change these criteria by sending some letters to the Council saying that they reserve the right to attack a given non-state actor, but actually in the territory of a third country, because they pose a threat to their own stability and security. So I think if you want to include the morality in legal arguments, we cannot avoid this ingredient of realism in politics for understand how the system was established as it is working right now.
Thank you. Kathleen, you want to jump in or leave it there?
Yes, maybe I'll just make a brief remark on that. I think morality, first I should just note for the record that the Treaty on the Prohibition of Nuclear Weapons does raise the ethical dimension of nuclear weapons in the preamble as one of the reasons for banning them, and in quite strong terms. And it also refers to the Martens Clause under international humanitarian law, not as it doesn't use the term Martens Clause, but it uses the wording, meaning that it recognizes that any use of nuclear weapons would be abhorrent to the principles of humanity and the dictates of public conscience. And in doing this, it is recognizing this moral dimension or this ethical dimension, so this unacceptability in moral terms of nuclear weapons. The other remark I would make, and I agree that there is with Alejandro that there's a certain complexity to this, and also to how nuclear weapon states are presenting moral issues as regards nuclear weapons as well. I would say, just looking at it from an IHL lawyer's perspective, IHL itself, as Alejandro mentioned, is very much rooted in moral and ethical issue, a sentiment, if you will. IHL, human rights as well. And what is at the base of this law, because these are legally binding rules, IHL, International Human Rights Law, but all of these rules, before these rules were developed years ago, there was a societal decision. We decided as a society and as humanity that these rules were needed. And what grounded our decision was a profoundly moral sentiment. So for example, the prohibition to use indiscriminate weapons is very much it was a societal decision that there's something fundamentally and morally wrong about using weapons that will, without distinction, strike civilian objects and military objectives, and that this is wrong when carrying out warfare. And every rule of IHL is fundamentally based on an ethical decision of society and of humanity. So at that level, I think there is, yes, indeed, a very strong connection between IHL and morality. I do think it's a shame because we do hear nuclear weapon states will somehow evoke ethic or moral reasons for retaining their nuclear weapons. And this is all tied into the doctrine of deterrence and them justifying retaining these weapons to keep their populations secure and the world stable. But as we know, this is an extremely flawed argument, knowing all of the near misses that the world has come very, very close to nuclear war being launched by accident or miscalculation over the last decades. And there are many, many known examples and probably many more unknown examples that have not been made public. And the risk of use of nuclear weapons is increasing dramatically, especially today in the unstable world that we're in. And so this militates now for the urgency to get rid of these weapons. Thank you.
Thank you very much, Kathleen. We have one question from Peterson Benjamin. Peterson, thank you.
Hello everyone. Can you hear me?
Yes, we can.
Okay. First of all, a big thanks to all the speakers we had the privilege to listen today. My question is addressed to Ms. Lawand. Does the ICRC feel itself more or less satisfied with the advocacies it has led since many decades for the respect of both CTBT and NPT? In addition, with its convention on the prohibition of military or any other hostile use of environmental modification techniques, also known as N-Mode Convention. Thank you.
Thank you. First, I have to admit I am not, although I'm aware of the N-Mod Convention, we have not really worked on this convention so much in recent years, so it will be difficult for me to address that one. On the CTBT and the NPT, the ICRC and the broader Red Cross and Red Crescent movement, we have been committed to promoting these treaties alongside, of course, the Nuclear Ban Treaty, the TPNW. And we are, we continue to engage in dialogue with the states parties to these treaties. Well, the CTBT is not yet in force, as I mentioned, but we've been calling on states to, finally ratify it. So these are the Annex II states, the remaining Annex II state. These are the states listed in Annex II to the CTBT, and there are just a handful of states that have yet to ratify it. So we've been, calling on these states to join, and for the NPT, calling on the NPT states to start with, fulfill some of the basic commitments that they've made under the 2010 action plan. The action plan adopted at the review conference of the NPT in 2010, it was quite strong. I mean, they adopted 64 specific actions, including on nuclear risk reduction, also on taking certain steps towards nuclear disarmament, etc. As I mentioned, we believe the Nuclear Ban Treaty, for those states who are joining the TPNW, is a concrete step in fulfillment, not just of the action plan, which is a political commitment, but in fulfillment of the legally binding obligation under the Article 6 of the NPT. So we continue with this dialogue and promotion. Whether we are satisfied with the advocacies, I mean, we would be more satisfied if the results were a little bit more concrete. We would like to be able to see, more states joining the CTBT. We would like to be able to see more concrete commitments being implemented under the NPT. But we continue. I mean, we have to continue because this is a humanitarian imperative for us. And it's, the future of humanity, the future of future generations depends on the success of these commitments. And so we continue.
Thank you very much. We have just one final question from Florence from Trinidad and Tobago. Florence? I'm not sure her mic is actually working, but if not, I will just read it. It says, can either panelist elaborate on the repercussions or penalties that a state can face for violation of any of the international legal instruments preventing use and or development of nuclear weapons? That's a question from Florence. Yes. Who wants to jump in?
Well, I think that the responsibility of state is it's a given, of course. Those who are acting against international law will have some responsibility, but who's going to decide that responsibility? And that is to the court of law to decide, and it will depend on the damages, on the intention of the use of those weapons and the effects that can cause. I think it's difficult to elaborate on what kind of responsibilities will have the state, but certainly will have. But that is for a court of law, given all the information and the proof that the affected part of a third interested can provide to the judges. That's what I would add to this question.
Thank you very much. Yes, Kathleen?
Yeah, may I, if I may, Paola, and I know you're running out of time, but I noticed that there is another question by Mr. Munoz, I think, Gamaliel Munoz.
Yes, I think yeah.
Yeah, the reason, I'm sorry, the reason I do want to address that, because I just want to make perfectly clear, because he referred to my mentioning, you know, the possibility of bringing again the issue to the ICJ, back to the ICJ. I just wanted to make perfectly clear, I was offering this as an option, you know, saying this, I was presenting as an international lawyer, just answering in a very clinical way a question of, well, what might be the options for states. I'm not at all, just to be perfectly clear, I am not at all, neither in my personal capacity nor on behalf of the ICRC, advocating for this, okay? This is, I'm just mentioning it as a possibility, and I just wanted to make that clear so that I'm not quoted as saying that I'm calling for this to go back to the ICC. This is really up to states to decide. And all I know is that a number of states over recent years have been raising this possibility.
And if I may, I don't think there are any steps already taken in order to bring again this topic to the ICJ. I think there is no room at this point in time for that. The last request for the advisory opinion to the ICJ on different topics had been very difficult to approve the resolution from the AG of the UN. So there is no really an interest of a group of countries to bring again this to the ICJ.
Thank you very much. Yes.
I may ask a quick question from both Alejandro and Kathleen. And first of all, thank you very much for an extremely rich discussion. I really enjoyed it. And I think judging by the quality of the questions as well from our participants, this is something of interest. Mine is more of a political nature, but obviously with an international law link. Given the blatant disregard of the current US administration for international law, not only in the context of nuclear and other weapons of mass or any other treaties, exercising not just the right to withdraw and thereby weakening the treaties, but ignoring their obligations on the treaties. I mean, do you see that this kind of bullying tactic will influence other countries to have a disregard for international law as well? And over the long run, how will this impact the strength of collective international law? Unfortunately, I think I know the answer, but I want you to weigh in. Thank you.
Well, thank you, Jean, for your interesting question. I think we all know that the U.S. administration is against multilateralism. They want to interpret their own legal system as sufficient for everything that deals with the U.S. actions abroad. I think the latest of these acts was against the ICC prosecutor because she was requesting to the judges permission to investigate on a given circumstance in Afghanistan dealing with war crimes, and the judges agreed. And then the US took some sanctions, but not against the court, against the individuals bringing service to the court, which is a bit odd in international law. So this is, I think, an action that they implement because they can, and no other country. I'm not justifying, and I think it's a clear opposition of a number of countries in that context against this. But I don't see anyone else trying to do in that particular way this disengagement with international law. There are obviously some countries that are denouncing some treaties, but they are following the proper way in legal terms to do it. But I hope that none will follow this attitude from the US, because it's damaging the international law, it's damaging the multilateralism, and in the end, it's making the world more dangerous in my mind. If one believe that they can handle all the issues that have impact in the world by its own rules, but then we will go back to times when it was the law most powerful. Thank you.
Thank you very much.
May I briefly add to that? If I could just say that, well, first, it's a delicate question as formulated for me to respond to as a representative of the ICRC. But what I would say in more general terms is the rule of international law is critically important. And we understand by that, of course, respecting and ensuring respect. So states respecting and ensuring respect. So as a collective, as a matter of collective responsibility for international humanitarian law in particular, so the law of armed conflict and rules in conflict. And there I would say what is critically important, and I will take the example of the use of chemical weapons in Syria. As you know, we had a very strong norm against the use of chemical weapons for years, which had been more or less respected. And then in recent years, there have been repeated reports and confirmed reports of use in Syria. And okay, there are whole debates about who was responsible, and I don't get into who's responsible. I don't care. The fact is, this norm was violated repeatedly and has been violated repeatedly in Syria. And what's critically important there is for states to react to this. We talk about, there was a question earlier about customary law, opinio juris, etc. I mean, for every time there's a violation of the law, of course, in some respects, it weakens the law, but what compensates for that weakening affected by the violation is the reaction of the international community. And this is where it is critical for the international community to repeatedly intervene. The majority of states, and the broader internet, it's not just states, it's also civil society, it's international organizations, etc., to clearly state and publicly that certain behaviors are wrong and that we must uphold existing law and the existing international legal regime that is aimed to protect civilians and combatants from unacceptable weapons, etc. So the reaction and standing up and upholding the law is critically important to ensuring that it remains strong.
Thank you.